Lawyers of the Member of Parliament for Assin North, Joe Kwesi, have withdrawn an application to invoke the supervisory jurisdiction of the Supreme Court for the court to interpret certain constitutional provisions. The MP's lawyer, Justin Poivra Teriwaja, had tried without success to get the Cape Coast High Court hearing the election petition involving the MP to refer Article 94, Clause 2A of the 1992 Constitution to the Supreme Court for interpretation. The five-member court, presided over by Justice Apao, struck out the application after the MP's lawyers had withdrawn it. The judges explained to the lawyer that he should have formally applied to the High Court to refer the said constitutional provision to the Supreme Court for interpretation, and if the judge had refused, then there would have been sufficient grounds to refer same to the Supreme Court. An amount of 5,000 cedis was awarded against the MP as cost. Meanwhile, the Cape Coast High Court is expected to deliver its ruling in respect of the election petition, which have at the center the matter of alleged dual citizenship of the Assin North MP on Wednesday, 28th of July.
And this is what happened yesterday at the Supreme Court, but as we know, there's some fresh document that's been filed at the Supreme Court. Joseph Akable was explaining a bit of that when we did the review a bit earlier. There's the jurisdiction of the Supreme Court that's been invoked to do some interpretation. But he explains that we do not know when that will be heard because of the vacation that the judiciary takes around this period. But we'll try and, when we raise our lawyer on the line, to see if there's been some development on that. But as you're aware, the schedule for the dates for the ruling in that petition, that parliamentary petition around the Assin North Member of Parliament, that is expected today. But would it even happen, considering that we know there's an application before the Supreme Court seeking to interpret what originally the petitioner was looking at doing? We'll try and get some answers and a bit more clarity on the subject. But this all may possibly have some implications on Parliament. As you know, it's a very divided Parliament that we have now. But for one independent candidate who chose to sit on the NPP side, we will not even have a majority as we have it now. Dr. RASHEED Draaman is a man who's been following a lot of parliamentary works, not only in Ghana, but on the continent and elsewhere. He's joined us for a conversation. He's the Executive Director for the Africa Center for Parliamentary Affairs. A very good morning to you, Dr. RASHEED Draaman.
Good morning, Mama V.
How much of the court processes have you been following? At least we have two that seem to be nearing getting to some kind of conclusion, Jomoro and the Assin North Member of Parliament. What do you make of the new developments?
Well, it's very interesting, Mamavi. I've been following the court proceedings very, very carefully because I know the outcome would have a very significant impact on the balance of power in the 8th Parliament. And I mean, I can't predict what is going to happen. But, I mean, at the end of it all, if the kind of developments that we are seeing is anything to go by, I am predicting that maybe the case might end up the disadvantage of the NDC, and then we will live with some serious consequences. I mean, the NDC will live with some serious consequences, because then we are going to have some clarity. Because right now, there's a lot of argument, even as early as yesterday, when we had an event in Parliament, there was an argument about whether the NDC has the majority or not. And I guess once these court cases are settled, we are going to have some clarity.
Just before you move on, is that an issue whether or not the NPP has majority? Haven't we crossed that line? I mean, we can't reverse the things that we've done, can we?
Well, we cannot, but yesterday we had an event in Parliament where the majority leader said, and I quote him, he said that the Right Honourable Speaker, I think in one of the proceedings in Parliament, referred to him and Honourable Aruna Idrisu as co-chair. And then he said that this was only in the imagination of the Right Honourable Speaker because he didn't know where that came from. And that if even the MPP has a half personal advantage, it was still a majority party in Parliament. So it looks like the debate is not over yet. And I think if we get to a point where these court cases are settled, and particularly if it goes in favor of the MPP, then perhaps that might settle the matter.
Okay. Well, as we wait to hear from the court, we just want to do some analysis, and I want to ask if it goes for the NPP. I mean, if it goes, I mean, the worst is we have to get a rerun. So even at that point, we will not know where the seat will go to. So for a while, we still would have a gap. But I'm just asking, if it goes in favor of the NPP, we can't reverse the election of the speaker. It's already done, right?
Yes, no, we cannot reverse the election of the speaker. You know, electing a speaker is much easier than removing a speaker. For the election of a speaker, you need a simple majority. But if a speaker, for any reason, will have to be removed from office, you need a two-thirds majority. And right now, I think given the balance that we have in the House, it will require about 200 and something members voting to reverse the decision of January 7th. And I don't know whether either side can have that number. Particularly, I think in this case, it will be the MPP that would be trying to take such a step. And I don't know if they can master the 206 that will be required to reverse that decision.
What happened again in line? And let me welcome to the conversation our lawyer. No, not Dr. RASHEED Draman, but we've got a lawyer joining us in a bit. But Dr. Draman, just on this same line of thoughts, the second Deputy Speaker of Parliament, he's the man who chose to sit with the NPP. Reason they have a majority party in Parliament. What will become of him?
Sorry, I didn't hear the question.
So my question is the second Deputy Speaker of Parliament who chose to sit and go with the NPP. Reason NPP has one difference. I'm asking what will become of him. Again, along the same line of if this goes in favor of the NPP party.
I'm not too sure about maybe the changing the deputy speakers. I have to double check on that. But what it would mean is that, you know, in the event that these court cases are finalized and I mean, hypothetically it goes in the favor of the NPP, there is going to be, if you like, a lot of constitutional issues that would need to be settled. And that is why, right from the beginning, most of us have been calling for some consensus and some compromise so that we avoid a situation where we end up in a gridlock in Parliament that would cripple the work of the legislature for a very long time. I've seen this happen in many parliaments where, as a result of carpet crossing and so on, all of a sudden one party loses its majority, and then the processes drag on in court to the extent that the parliament is paralyzed. We want to avoid this, and the only way to avoid this is if there is some compromise, because if we know, for instance, as I said it earlier, we cannot have, one party cannot have the two-thirds majority to remove the speaker or, to change, certain decisions. But maybe for the sake of trying to cripple the other side, some attempts are being made. It is just going to stifle the work of the legislature, and then we get into some kind of crisis that could drag on for some time.
Okay. Let me say good morning to Christian MALM-HESSE. He's a lawyer. He's joined this conversation. A very good morning to you, sir. Thank you for your time.
Good morning.
Great. So we've been reporting that the High Court is expected to rule in this matter of the Assin North Member of Parliament because of the petition, sent to that court. But yesterday, there was also some process filed before the Supreme Court invoking its original jurisdiction to interpret, and I want to read it to you, what this petitioner, this plaintiff is seeking before the Supreme Court. Is a declaration that on the true and proper interpretation of Article 94(2)(a) of the 1992 Constitution, a determination of a person owing allegiance to a country other than Ghana, such as disqualifies such a person from being a member of parliament in Ghana, involves consideration of the law of the country other than Ghana to which it is claimed the person owes allegiance. The second one is a declaration that on the true and proper interpretation of Article 94(2)(a) of the Constitution, a person who owed allegiance to a country other than Ghana but has taken positive steps under the law of that other country to renounce the allegiance or citizenship of that country does not fall within the scope and meaning of a person who owes allegiance to another country other than Ghana, as expressed in the same article. The third one is for the courts to again interpret the same article. The issue of owing allegiance to a country other than Ghana requires evidence of acts of allegiance by the person to a country other than Ghana, such as to disqualify the person from being a member of parliament. I think there are three more, but we can end here because it's the same matter that the petitioner in the High Court sought to do at the Supreme Court, which was struck out yesterday. But my question is, in view of the fact that this process has been filed, will the High Court be minded so that it would hold on its ruling today?
No, its ruling would come off.
Okay. All right. So because I asked that because in the instance where they had gone to the Supreme Court, the judge decided to hold on and hear from the Supreme Court before it goes ahead with the ruling. So I was just checking if because this action was initiated yesterday, the judge would still say, okay, somebody else has gone on this same matter, so let me hold on. Or this has nothing to do with the matter in Cape Coast.
Circumstances where it is a preference mostly of the courts, especially where the matter filed at the Supreme Court would have a derivative nexus on proceedings at the lower court. In that situation, the court would mind itself to stay proceedings and await the outcome of the proceedings from the Supreme Court. But where the coordinate jurisdictions are parallel and have no direct bearing on what the lower court, albeit the High Court, would do, the court could progress to give its consequential ruling.
Let's talk about the consequences, possible consequences of this ruling, and I'll leave it to you to digest it.
I mean, yes, definitely. The ruling of the courts would have an impact on on the political landscape, especially what would also happen in Parliament. It is a matter that borders on dual citizenship, but the important thing for us to look at is whether or not the said MP renounced his citizenship before he got himself to the polls, and particularly whether or not where a person conducts himself in the manner that is required by the rules of the land to give off all duties or obligations required of him under the law, to renounce his other citizenship from another sovereign nation before he gets to the polls, and whether he gets his certificate before the polls. What I'm basically trying to say is that if one takes preparatory steps to give off whatever obligations is required of him to renounce his certificate, the point is that, did he do that by perfecting an imperfect gift? Did he do that by transferring all those obligations to a third-party institution, and whether or not the third-party institution reverted back to him with his certificate of renunciation? Now, if he was able to renounce, if they themselves in court had proven and discharged the burden that, yes, he renounced his certificate before going to the polls, it could be a tentative legal point for the balance of justice to tilt in his favor, where the court comes in considering equities in trust and looking at perfection and imperfect gifts, especially with a doni and dona or such power. But where the court is minded that it would not consider such equitable principles under trust, then we could see the matter going against the said MP.
Dr. Draman, if you can hear me, we've had a situation before in the fifth Parliament, I think, with Adamu Dramani Sakinde. I want you to refresh our memories in terms of the significance of what happened to him in that Parliament.
Well, I mean, what happened to him, I think that was the fifth Parliament. What happened to him was that, he had dual citizenship, Ghanaian and British, and he didn't renounce the British citizenship before he got elected as a member of Parliament. And I think a cattle farmer in his constituency took the matter to court, and then eventually he was jailed. Regrettably, I think he recently passed. May he so rest in peace. So that really, set the precedent in terms of what we are going through currently. But for me, I think I've had occasion to say this, I think on your platform as well as at the platform, that this law is cake. I think if there is going to be any constitutional revision in our republic, this is one of the clauses that I think should be revised. Because look, on the one hand, when we are counting our GDP and we are counting our resources, we pay tribute to the contribution that the diaspora makes economically. But when it comes to political contribution, we turn around and say, no, these people cannot. You go to other jurisdictions, you can hold, 5, 10 citizenships. Nobody can. In Canada, for instance, recently, even the leader of the opposition had dual U.S.-Canadian citizenship. And I know a lot of Africans, when I lived in Canada, a lot of Africans who went to Canada still holding on to their African nationality, their country nationality, ended up being members of parliament and so on. I think we just need to strengthen our institutions and strengthen the processes that would perhaps prevent any abuse of any kind of power that a member of parliament has, and so on, when he or she holds, allegiance to other kind of nationality. Otherwise, really, I don't see, the benefit of this. It blocks a lot of good people who want to be part of the political process from doing so.
Christian MALM-HESSE, I want to come to you now. It's interesting, isn't it, that nobody has before, well, at least until this issue came up and yesterday, nobody thought that we needed some interpretation of this particular provision, which stops persons who owe allegiance to other countries from being, standing as a member of parliament.
Hello, I would want to add my voice to what Doc said.
Yeah, I was just saying that it's interesting that nobody tried to get some clarity. It looks like it's always been clear. Nobody thought that there was the need to get interpretation of this particular provision.
Oh, invoking the original jurisdiction of the Supreme Court, it goes without saying, once you could link the nexus to constitutional provisions and seek interpretation, those are the two ambits that the court would entertain you. But the more interesting thing is that the jurisprudence behind the dual citizenship.
Okay, we seem to have some network challenges.
It goes to all citizens, particularly when one is seeking to become a member of parliament. You cannot owe allegiance to another country. Purposes for security reasons, and especially because of the history that we have had. The framers of the Constitution deemed it that you could not owe allegiance to other country where you have distracted citizenship, or for want of better word, your internal mind is connected to two countries. And when that situation happens, it will not augur for the sovereignty of the state. And that is why this has become a qualification for members of parliament. And more interestingly, if you look at the other parliamentarian who Doc also referred to, his situation is quite different from this particular situation that we have. The legal issues that existed at the time was that was whether or not he renounced his citizenship. And importantly, he did not, but he lied. He lied and he was charged with perjury. And culminating with all of that, that is why he ended up in jail. And we know perjury is a quasi criminal matter. So those were the important things that existed in that particular matter. But the case that we have currently before us is where the said MP had taken steps to renounce his citizenship, and that the renunciation process at the time was not within his ambit to determine, but was within the ambit of a third-party institution to issue him with a certificate. So now the question, as I mentioned, which is before the court, is to determine whether where one party going into such a national poll, particularly for an MP position, having renounced his position, having done all that is expected of him to be done as required by law, and awaiting his certificate from that third-party institution, is still eligible to stand for elections. And that would be a question for the court to answer.
All right, I guess we wait to hear that answer. We're all interested in knowing the answer. In the meantime, though, just a bit of education. What happens to what has been filed at the Supreme Court for interpretation?
Yeah, definitely. The court would go on to make its determination of it, because the Supreme Court is faced with all the inherent jurisdiction to hear that matter.
Dr. Draman, okay, no, just one point to clarify. Could this, depending on where it goes, and I'm not by this question determining that it's going to go a certain way in particular, could there be possible criminal procedures that will follow? Could the police pick up from where the courts will leave it? Christian MALM-HESSE, this is for you.
Yes, I mean, where there is no criminality involved, the police will not even come in. And the criminal matter comes in where one has committed the offense of perjury. You understand? And that is a matter to be determined by the court. And the police will not come in as of now. Okay. It's a matter to be determined by the court. And just as I explained, the peculiar circumstances of this case is determinable based upon whether or not the said MP was able to renounce his citizenship, albeit the other one, before he went to national polls, before the rate of elections was issued. That is the most important critical point that the court would put a lot of emphasis on in coming to conclusion in the matter.
All right. Dr. Dramani, you wanted to say something?
No, I mean, I'm just also getting some legal education.
Okay.
Yeah, certainly, I mean, in this case, I think the big question and the big difference as the legal person has explained is that, I mean, the two MPs are indicating that they renounced their citizenship. And now the issue is, whether at the time of filing to contest they had their certificate of pronunciation or not. And that's actually the difference between this case and the other one. I mean, these cases and the other one where there was clearly no renunciation, but I mean, the MP did not tell the truth at the time.
Well, I want to say thank you to you, Christian MALM-HESSE. Dr. Rasheed, just a final one with you. We have one pending. You just added it to it. There's the Jomoro one. What happens when an MP is in this legal battle? How useful are they to Parliament at this point?
What happens? What?
How useful are they to Parliament? So how useful are they to Parliament, particularly at this time when they have their own legal battles ongoing?
Well, I mean, the thing is that, I mean, I believe they will try to put up a brave face and try to do their work as members of Parliament, but this will be a lingering worry, I mean, for them until the case is determined. I'm not too sure that they are happy and free-minded MPs at this moment as their other colleagues are.
All right.
And, well, I just hope that this matter is determined as these matters in court are determined as quickly as possible, so that at least we can put it behind us. Because sometimes the wheel of justice winds very slowly in our country, and we don't want this to drag on until the end of this 8th Parliament.
Absolutely. Dr. Draman, I have a feeling that we will speak some more tomorrow, depending on how the case goes today. So talk to you soon, I guess. Dr. RASHEED DRAMAN is Executive Director, Africa Center for Parliamentary Affairs. At this point, there's a limitation on what we can say and what we can analyze. But I guess when the voice of the court is heard today, we can do a lot more analysis, but there will certainly be implications. Stay with us. We have our next conversation to come later on. Joe Metal is live here on the AM show. You don't want to miss it. Stay with us.